This is an appeal in the matter of the claim on the application of RR at the London Borough of Enfield.
Good morning, Miss Davies.
Good morning, my lords and my lady. I appear for the appellant claimant in this matter, in respect of whom there is an anonymity order, so we refer to him as RR and his wife as ED, and I'm assisted by Mr. Banno behind me, who appeared below, and as my lords and my ladies can see, quite a team from the Law Centre. And Mr. Paget appears for Enfield.
He doesn't seem to have quite such a large team.
I offered that some of mine could move over and sit behind him for the purposes of the live stream. Can I deal with housekeeping very quickly? Then then I'll explain the order as Mr. Paget and I have discussed. Do my lords and my lady have a core bundle which includes both parties' skeletons. There's a supplementary bundle which was revised at the end of last week, and I have a short application in respect of that, and there's a bundle of authorities, and replacement skeletons were filed yesterday, which was a little late. I apologise for that.
We got an extra bundle yesterday, didn't we?
There was some confusion about whether or not the Court of Appeal Office had the bundles that were filed on Friday, but the relevant supplementary bundle.
Well, I've got a supplemental bundle of 438 pages, including, perhaps most interestingly, Enfield's Equality Impact Assessment, dated 15th of May 2020 something. We don't know what.
202, yes, we don't know what it is. Maybe Mr. Paget can help. It's on the document itself that the date has been cut off, so we can't help on that.
Well, he can ask those instructing him who sit behind.
He can, yes. Maybe the miracles of modern technology. I'm grateful, so that is the correct.
Do you know if it is the one before the allocations policy that's at issue in this case, or whether it's the one that came for the new allocations policy? Or the bundle down below, for example?
No, it's clearly not the Equality Impact Assessment for the allocation scheme that was adopted this year, 2025, because we've had the document prior to that.
Right.
So our guess is it's either 2020, which is where the allocation scheme that's the subject of these proceedings is considered, was adopted, or it's 2021 when it was revised. And my lords and my lady, how I propose to deal with this is I have a short application in respect of the bundle. Mr. Paget then has his application in respect of the appeal being dismissed on the basis that it's academic.
I think we're going to just hear it all together.
I'm grateful.
I'm afraid we're not going to determine applications, those kind of interlocutory applications. Mr. Paget will be perfectly entitled to make his submissions about how we shouldn't deal with it in our judgments, and we should just dismiss it as academic when he has his say.
I'm grateful for that. My intention...
We're all here, you see.
We are all here, yes, and en masse. My intention had been to respond to Mr. Paget's application very early on in my opening.
Well, I mean, you
maybe
can.
I'll do it in reply.
You can take your own course if you want to.
I'll do it in reply.
You do it in
I'm
reply.
grateful.
Yeah.
And then what I was going to say is I have an opening that deals with some introductory remarks, then facts, then law, and then I have an application in respect of new evidence, and then I will go through the full grounds. So that's my plan for this morning. We do have an application for permission to rely on the supplementary bundle exceeding 350 pages. As my lord has just said, it's 438 pages. So
we will allow that.
I'm grateful.
And all the material was material before the court below. It's not new material, is it?
The Equality Impact Assessment and the... There were two documents that were before the court below but had not made it into the supplementary bundle, and that was the Equality Impact Assessment and the Emergencies and Exceptions panel decision. Everything else, all the additional pages, were generated as a result of Mr. Paget's academic application that the appeal should be dismissed. I'm grateful for those indications. It allows me to open substantively. And my lords and my lady know that this is an appeal against the judgment of Her Honour Judge Walden-Smith, which was on the 3rd of October, of last year, in which she dismissed grounds that the Enfield's allocation scheme failed to make reasonable adjustments under Section 20 of the Equality Act, was indirectly discriminatory under Section 19 of the Equality Act. She upheld the ground that there was a breach of the public sector equality duty and declined to order a remedy under Section 31(2)(a) of the Senior Courts Act. We appeal against the decisions dismissing the reasonable adjustments and indirect discrimination claims and the refusal to grant a remedy, and Mr. Paget appeals in respect of the finding that there was a breach of PSED. My Lord Lewis has just made the point that there is a new allocation scheme which is in the bundle, but I can say, first of all, obviously, this claim arises in respect of the allocation scheme that was adopted in 2020 and was revised in 2021. But for our purposes, there is no material difference. Because, as my lords and my lady know from your reading, the issue is whether the cap on homeless households, preventing them from being awarded points reflecting disability, specifically health and well-being points, is discriminatory under the Equality Act, and that cap has been reproduced in the 2025 allocation.
Is it right that households with the highest level of disability can get 1,000 points rather than the 200 points? It's only therefore the medium and low levels of disability, the 150 or 50 points, that they're prevented from getting.
Yes, so if we turn to the allocation scheme, and the easiest way to understand it is to look at Appendix A, which starts at page 62 of the supplementary bundle.
Yeah.
So my lords and my ladies see the point summary table,
Mm-hmm.
and 1.6 is my client and those in his position.
1.6.
1.6,
Yes.
which is the penultimate one from the bottom. Homeless application, living in accommodation provided by Enfield Council a main homeless duty under the homelessness legislation. Became homeless after November 2012 and is living in temporary accommodation, 200 points.
The starting point is at the top of the page. You go into whichever category gives you the highest points.
Yes. And
if
there
you went
was
into category 4, you'd get the 1,000 points, wouldn't you?
Well, there was a decision to that effect, and that decision was this is the new material in the supplementary bundle, but as I say, it was before her honour. That's page 427 of the supplementary bundle. And that was an application to the emergency and exceptions panel.
And they decided that he didn't meet the criteria for 1,000 points.
Yes.
But had he met the criteria, he would have got the 1,000 points, not the 200 points, as I understand it.
Would my lord give me one moment? I'm so sorry, my lord.
That must be right, because the panel engaged with whether this was a high health and well-being case. So plainly they were looking at whether this family or this woman particularly came within the high category for health and well-being and decided on the facts that she didn't.
Well, clearly that's how one read it. I'm being told But Enfield's position is different, and Enfield's position is that you cannot switch.
Well, if you look at the top words on 62, applicants may meet more than one of the criteria, in which case they will be put in whichever category would award them the highest level of
Yes.
points. 1 point, the first category is homeless or threatened with homeless, and they were in that and they get 200. Then there are other categories, insanitary housing, overcrowding, but 4 is a category of health and well-being. And if you meet those criteria as defined, you are in that category and you get 1,000. So I don't quite understand how it could be suggested that people who are in the high health and well-being need don't get the 1,000 rather than going into some other category. It's just the same as being in unsuitable housing. You still would go into the 1,000 points if you could show you met the criteria for category 4.
Yes, I understand. Would my lord give me a moment? My lord, I agree with the analysis. I am told very clearly that Enfield's position in the administrative court was that it was not possible to, as it were, switch to obtain the highest possible points under 1, 2, 6.
Well, shall we hear from Mr. Paget
That would be
about that
helpful.
in due course? We won't delay now.
Yes.
It's probably not the central point in the case, but it is just relevant to know.
Well, it is certainly relevant to know, but it's not the central point, because if it's not on the basis that one can switch, I'm using a very colloquial term, but that one can change categories, and so a homeless applicant who had high health and welfare points would receive 1,000. On that basis, we would say there is still a discrimination aspect in terms of somebody who is homeless and whose household containing a disabled person does not meet the high health and welfare or the emergency and exceptional, but would normally have a medium or low health and welfare and well-being need. And in those circumstances, a household who is not homeless but falls within one of the other criteria in the allocation scheme, insanitary or unsuitable housing or overcrowded housing, for example, can apply for the medium or low health and welfare points, and that will be assessed, and they may or may not receive them. Homeless households cannot do so. The discrimination here is not between homeless households and non-homeless households. It is in respect of homeless households where there is a member of the household who has a relevant disability, as against homeless households. But all of them have their points capped at 200.
So why does it make a difference? Can you help me? Why are we looking at what would happen to a non-homeless household where there was medium or low disability, where they could apply to have those points totted up effectively? Say they were an overcrowded household and there was a medium disability, and so you'd be looking to totting up. That isn't the comparator, is it? On your case, our comparator, you're looking at other homeless households where there is no disability.
Yes.
That's where you have to show us that the PCP causes discrimination.
Yes.
Am I right? Have I got
Absolutely,
that right?
that's absolutely right.
Okay.
And I got there in a convoluted way,
All right.
so it was, as it were, the second half of my sentence. But that is our comparator is what I'm going to call disabled homeless households, by which I mean a homeless household that has a member that has a disability.
The comparator is the non-disabled homeless.
Sorry,
You are the disabled homeless.
Yes, and the comparator is the non-disabled homeless household. And for the sake of ease, I'm going to say disabled homeless household and homeless household.
Yep, okay.
But that's our comparator. But I draw attention to the fact that the scheme does allow for additional preference, but not in respect of homeless households. And our principal point is that people who, as a result of being disabled household, have a need for a particular type of accommodation, and have more difficulties in obtaining that type of social housing, than those without a need for a specific type of accommodation, the homeless households. And so this case is about levelling the playing field. And
But that's nothing to do with their disablement, that's to do with the supply of available housing.
It is, but the effect of the supply of available housing and that the stock of properties for those who need a specific type of property reflecting their disability is smaller than those who do not are in general needs, could take any type of property. And the evidence that says that there is an insufficient supply of such social housing is in the Equalities and Human Rights Commission report, which was before Her Honour, from 2018, supplementary bundle, page 76, it starts. And at page 96...
So which page?
It starts at page 76 of the supplementary bundle. And at page 96, the EHRC in 2018, 7 years ago, says it's widely recognised that there's an insufficient supply of affordable housing, while current housing stock across Britain is often not accessible or adapted to meet disabled people's requirements. Room sizes are small, many have baths rather than showers, which is one of the issues in our case. There are steps to the front doors.
How does that tie to the PCP? Because the PCP has to be applied, it has to be discriminatory. And if you're comparing the disabled and the non-disabled households, neither of them can get the extra points.
No, it's a neutral provision.
Yeah.
That's Mr. Padgett's point. But we say in relation to a neutral provision that creates a non-level playing field, an unequal playing field.
Between the disabled and the non-disabled homeless? But
Yes,
how?
because the homeless households have a greater pool of properties that they could bid for. And therefore, not necessarily in every case, but overall, we say that the disabled homeless households are likely to be waiting longer because they're bidding for a smaller stock of properties. They're waiting longer in Part 7 temporary accommodation.
Hold on a moment.
Yes.
Waiting longer because they're bidding for a smaller group of Part 6 properties.
Yes. They're waiting. Sorry, my lord.
Yeah.
They're waiting longer in Part 7 temporary accommodation. Temporary is a colloquial word used for accommodation provided under the Main Housing Duty, Section 193. And we say that waiting longer in Part 7 accommodation is itself a disadvantage because there is a lower standard of accommodation in Part 7. And we attempt, it's my ground one, but we attempt to point to the research from Shelter and others on the standard of accommodation in Part 7. Because Part 7 accommodation, although it's required in law to be suitable, we say that the evidence in this case shows that too often it is unsuitable. My client was in accommodation that was agreed to be unsuitable for about 20 months.
That's why you have a review and you have a right of appeal to an independent court to establish that.
You do. And he went through both of those processes. He went through the first process, the review. First of all, he was in bed and breakfast for about 5 months. On, I think, a request for a review, he was moved into a self-contained flat. He requested a review of suitability. It was agreed not to be suitable. He was subsequently moved to a second flat.
He had a second child, didn't he? And they needed an extra bedroom.
Yes. He was moved into a second flat, which was, after some delay, agreed not to be suitable. and he was given a third temporary accommodation flat in August 24, between the date of hearing and the judgment in this case. And that was suitable until he was given the private rented sector offer that he's now in. So as a matter of fact, he spent about 20 months in unsuitable accommodation.
But Miss Davies, I mean, I've taken a careful note of the argument, but the key to the argument is that the disabled homeless household is likely to wait longer.
Yes.
And the reason the disabled homeless household is likely to wait longer rather than the same amount of time is because of the shortage of accommodation in the pool, not because of the fact that it is a disabled household.
Yes, that's the reason. This isn't a direct discrimination claim.
That's causation.
It's causation. This is an indirect discrimination claim. And we say that that fact leads to disadvantage, substantial disadvantage under Section 20 or particular disadvantage under Section 19, the waiting longer, and that Enfield are therefore under a duty to make a reasonable adjustment in order to overcome that disadvantage. And we say the reasonable adjustment is very simple. It's to lift the cap to allow disabled homeless households to apply for the additional preference.
But can I just follow that through with you?
Yes, please
Ms.
do.
Davis, that what that means, what that would mean is that the homeless disabled household has a better position in relation to non-homeless disabled households. In other words, if you've got a small pool of adapted housing, and at the moment, in reality, I think your complaint is that the homeless disabled aren't getting a fair crack at that because others who are not homeless would get more preferential points totting up. So your argument is that the homeless disabled should be able to tot up as well by getting additional points because the properties they want are in this small pool of adapted properties. It's nothing to do with what the homeless non-disabled are doing because they're looking in a different pool effectively, or a different part of the pool, because they don't need adapted properties. So one of my concerns about this case is where it gets you to, and following because where it gets you to, if you're right to say the adjustment has to be that the homeless disabled family can have preferential points added, is not that they're in a better position as against other non-disabled people, but they're in a better position as against other disabled people. Because that's the pool of accommodation they're after.
They become the same position as other disabled people.
Maybe, but that's not your case. Your case, as I understand it, is all about the PCP. It's the prohibition that's causing the disadvantage.
Yes.
And I suppose I'm just saying to you, I'm struggling with that a bit, because it seems to me it's not the PCP that's causing the disadvantage, and amending the PCP isn't going to cure your problem, and the problem is a lack of housing for people with special needs.
Yes, so 2 points on that. First, it's not entirely adapted housing that we're talking about. And my client's case is a good example. His wife doesn't require a wheelchair. She requires level access, adaptations in respect of the bathroom, and ground floor accommodation. So that's equally general needs housing. Anybody without a disability might equally be bidding for such type of housing. If we were talking solely adapted housing, then the argument would be very different, because Enfield would want it, and in fact do, put that into a separate pool. So we are talking about general needs housing that anybody could apply for, but in the circumstances of disabled people, fewer of those properties are suitable for them or appropriate. Then we come on to
I'm not, just not following that. So we're not dealing, because there are special provisions for wheelchair adapted.
We're not dealing with that.
We're dealing with a subset of people who have a disability. We're having, are we dealing with those people who've got the duty owed to them because they have a disability, but the disability requires a level access and a shower, and some of the properties that have a level access and a shower would be equally suitable and open to be bid for by non-disabled
Yes.
persons. Is that the point?
Yes. Yes. So the non-disabled, a property that is suitable for my client and his family can be, is not ring-fenced in the way that a wheelchair adapted property would be. And therefore, he's bidding for it, as are non-disabled homeless households.
Yeah.
But the non-disabled homeless household, the next week, is bidding for other properties on the second or third floor, or they have more opportunity to be successfully housed under Part 6. Fewer of the properties that come up each week or each fortnight are accessible for his wife, and therefore fewer of them are possible for him to bid for.
Well, that's the next question. You say that, but do we know the figures on that?
We don't.
Because we don't have the figures of proportions of disabled versus non-disabled. We don't have the waiting times, do we?
No. And that's one of the reasons why this case is principally about Section 136 and the burden of proof. Because, of course, it's very hard for us to get those figures.
Well, we know that 150 disabled houses, homeless people were given social housing, but we don't know any more than that. Do
No, and we know from the equality impact assessment, which, as I say, we believe to be in 2020 or 2021, and it starts at page 413 of the supplementary bundle. And disability is considered at page 416. We don't know about the figures for Enfield, but we know Enfield advised themselves on the national figures, which is that the number of people with disabilities and medical conditions on the housing waiting list in England had risen by almost 11,000 in 2 years.
But do we know anything about whether the number of non-disabled houses had also risen because there's a shortage and more people claiming?
That is, of course, nationally available, but in answer to my Lord's point, that takes us very much to ground 4, and what we say was...
But even though, let's do this for the moment, 416, we don't have the figures for the increase in the non-disabled homeless people, whether that's increased.
No, although that...
And those are available nationally.
That exercise could be done by us,
Yeah.
I accept that. But we also don't, I mean, in terms specifically of Enfield do not tell us, or themselves, how many households with disabilities are on the register, how many of those are homeless households, stroke, how many homeless households there are without disabilities, and nor do they tell us what the waiting time is. What we do know from the national figures from the EHRC report is the shortage of accessible accommodation. We know that Enfield have acknowledged that 600 households are in unsuitable accommodation.
Where is the 600? I couldn't find that.
That's in there. It's quoted by the local government and social care ombudsman in response to a complaint that he finds made out against.
Where is it in the bundle?
It is.
I saw the complaint, but I didn't see the 600 in it. But
I'm grateful.
sure it's there.
It is page
Starts at 305.
305. Thank you. So the that is at page 312. And if my Lord has it, it's the bullet point immediately above
I see it.
analysis in bold. And that's the council's comments.
So that's 600 households who are not being provided with that which is a matter of law they ought to be provided
Yes.
with under Part 7.
Yes. And what they have also said, and that's the BBC report, is the obvious point of significant lack of affordable housing in London and the South East, and but a handful of properties in Enfield that are suitable to those with additional needs. Now, I accept that both of those are in relation to my application for new evidence. I accept that. But the problem that we have always said we have is that we have brought this claim with what we say is sufficient for Section 136, the burden of proof. But insofar as the statistics are relevant, those are not available to us. They are in Enfield's domain.
Well, you could have got the national figures as you did in Begum in the Court of
We
Appeal.
could have got the national homelessness
and
figures.
tried to draw inferences from that on the grounds that Enfield is the same, or you could have made a freedom of information request, or you could have made a Part 19, whatever it is, request, couldn't you?
We made I accept the point about national figures entirely.
Yeah.
We did make a freedom of information request, page 300. This is one of the three pieces, the three materials that Her Honour refused permission to rely
Which
on.
page?
Page 300 in the supplementary bundle. We asked about, at 5, well, one starts at 3, total number of temporary accommodation units.
You're asking about Part 7 then, are you?
Yes, temporary accommodation means Part 7. And then at number 4, we said the number of temporary accommodation units held which are fully accessible. Enfield did not have that information, though they were aware of 2 recent properties that were. We asked about the total number of Part 7 applications whom the main housing duty owed who do not have accessibility needs. So we ask about the number of homeless households. And then we ask at 6, how many of those had a private rented sector offer, and that was 52. And we asked about the number of Part 7 applicants requiring fully accessible properties who've had duties discharged through a private rented sector offer, and they didn't have that information. And over the page...
That's all to do with Part 7, is it? If they are offered a private sector tenancy, then the duty under Part 7 comes to an end, is it?
Yes.
Right.
Yes.
So you didn't ask specifically about Part 6, did you?
No, we were asking about private. We were asking about 2 things. We were asking about private rented sector offers and temporary accommodation. But I repeat the point that what we had to fulfil before Her Honour was the test at section 136, which is whether there were facts from which the court could decide, in the absence of any other explanation, that Enfield contravened the provision concerned. And that the facts that were available to us, with our best endeavours, I take the point that we didn't ask about Part 6, but with our best endeavours, were my client's own account of waiting and being an unsuitable accommodation, which goes to disadvantage. The EHRC report, which sets out starkly the shortage of accessible housing. And the EHRC say specifically that disabled people wait for a longer period of time, and I'll find you that reference. It is, sorry. It's page 136 in the supplementary benefit bundle. Of course, they're saying that nationally, not in respect to Enfield. Page 136, once an individual has managed to negotiate the opaque and complex housing application assessment process, they then face a lengthy wait. Our survey asked local authorities who held information on the accessibility of their housing provision to report the average length of time that disabled applicants spent on the housing register. Only 42% of local authorities reported waiting times for disabled people. And the last sentence of that paragraph, of those who were able to report on waiting times, the average length of time that disabled people waited was 25 months.
But do we know anything about the average waiting times for people, homeless people who are not disabled?
I don't have that information
Right.
for you, but they are saying, EHRC is saying that is a lengthy wait, and they specifically relate that to the shortage of accessible accommodation. So in terms of our section 136 burden, we had Enfield acknowledging that the numbers of people with disabilities on the waiting list generally was increasing in England. We had my client's account being in unsuitable accommodation, and we had the EHRC report, which paints a stark picture of the difficulties that disabled people find, particularly in social housing. And the EHRC report also says that disabled people are overwhelmingly represented in social housing. And that is page 129. Disabled people are overwhelmingly represented in social housing. I read that to mean more so than non-disabled people because of its lower affordable rent, security of tenure and provision of support. But demand for social housing outstrips supply in every part of Britain, and allocation policies and practices frequently disadvantage disabled people. And then they go back to social housing at page 139 of the bundle. Sorry, 137 and then 139. 137 starts, there is such a shortfall of social housing and so few accessible or adapted properties that it can take several years for disabled tenants to find appropriate accommodation. And then they deal with lack of information, including the fourth paragraph down, some local authorities are unable to say how many disabled people are on their waiting lists or what their requirements are in relation to adapted or accessible properties. And then so the point is being made very clearly in the EHRC report that there is a shortage of accessible properties, that for various reasons disabled people are overrepresented in social housing because of the advantages of social housing, and that disabled people face a lengthy wait. That's national research.
I mean, I get all that.
Yes.
If I may say so.
Thank you.
It obviously has a foundation. But you have to show that the PCP is discriminatory in relation to a relevant protected characteristic of your client. And the PCP is only the question of whether or not you get extra points for disability.
Yes.
And therefore you can only, to do that, compare the position of a non-disabled homeless person with a disabled homeless person.
Yes.
Vice versa, actually. And so the fact that in general, disabled people, because of an external feature, namely the lack of supply of suitable accommodation, don't do very well and have to wait a very long time, is it something that discriminates by the application of the PCP in question?
Well, we say it's enough for section 136 because making the point that information other than the national statistics are not available to us. And I take my Lord Justice Lewis's point that our FOI request could have included that information. I do take that point. But the statistics for Enfield are within Enfield's knowledge.
But what about the actual question? They're leaving aside the 136 point. If we're against you on what that means, and we were to take the view that you have to establish facts, the facts you've established so far is that disabled people face quite a struggle to get suitable housing under Part 6 because there's not much available.
Yes. Well, I say that's sufficient for Section 136.
Yeah, I know, but if you're wrong on that...
No, I did hear you. I did hear my Lord. If the additional difficulty we have is what Her Honour found to be Enfield's non-compliance with public sector equality duty. Because it's a separate ground, but it does go directly to the two claims under Section 20 and Section 19. Because had they complied, had they monitored, as Her Honour found that they should have done, then a lot of the information that my lords and my lady are making the point about would have been in a proper PSED.
So you can only win this case if you either win on Section 136 or 149 then, is that what you're saying?
No, I'm saying, I am saying, first of all, I win on Section 136. As my Lord put it, my Lord, the Master of the Rolls, put it a few minutes ago, and the exact words were being written down behind me, but that there is...
That's a comfort.
I'm so sorry. And of course it's writing, and I apologise for that. That disabled people face difficulties of getting into social housing. I'm getting more and more, less and less concrete, and I apologise for that, but we know what we're talking about.
Can I just rehearse what
Yes.
I think the Section 136, forgive me if I'm just plodding along behind, the Section 136 argument is that you say there's generic evidence about the difficulties that disabled people face nationally and across the board is a sufficient basis on which the court below could and should have drawn the inference that in relation to this PCP, once you apply that, it was a sufficient basis to say that you could infer that a disabled homeless person is going to have a longer wait than a non-disabled
And
homeless
that is
person
a
for Part
disadvantage.
6.
Yes, I do. And I say that the burden would then shift to Enfield, and they might be able to answer it. They haven't, we say, on the documents before the court, but it's not inconceivable that Enfield can make exactly the point that my Lord Justice Lewis is saying, that is there in fact a difference in waiting time? They could come back and they could say, no, there isn't, here are our figures. Or they could say that any adjustment would not be reasonable because when you look at the figures overall, it would subvert the scheme. That's the word that Her Honour uses. Or that an unequal playing field is nevertheless justified in terms of the indirect discrimination. They could produce all those statistics to show that in fact the inference is not made out. And they haven't done. And that does create a problem for us, the exact sort of problem that I'm having to address now, because it is, if it was an ordinary burden of proof, it is difficult to see without that full statistical analysis. But I'm sorry to come back to my Lord Justice Lewis. We therefore say that for those reasons, and because Enfield have that information.
That does sound as if you're saying we couldn't prove this unless the 136 allows us to do so. It sounds to me as if you're saying you couldn't win without 136.
No, I'm saying that we have sufficient for 136.
Yeah, but if we disagree with you...
And that, yes, but that's my principal point, that we have sufficient for 136, and that all the matters my Lord is raising are matters that were in the possession of Enfield, and they had the ability to raise in response, and they don't. So therefore, one, there is the inference, and two, that inference is made out because Enfield do not come back with that statistical analysis.
Hang on, so Enfield had the ability to answer, to provide the explanation in the words of 136, and we can infer from the absence of the explanation that the 136 burden had been discharged. Is that it?
The court can infer that the facts as put forward by the appellant are sufficient so that there could be a contravention. It may be, as I say, that Enfield can then come back with statistics to show that there is no contravention.
But that's entirely circular.
It is, but the reason for that is because of the reverse burden of proof at section 136.
It's not a reverse burden of proof. That's a label. It says that if you can show facts, you'd have to look at the wording.
It's a stepped burden of proof.
Yeah.
Yes, yes.
It's not right to say it's reverse.
That's how it's been colloquially described, but my Lord is absolutely right. It's not a reverse burden. It's that the burden then shifts if we get through being able to show that there are facts from which the court could decide in the absence of any other explanation. And I make the point that in employment cases, it has been very clearly said why that burden of proof is different to the ordinary civil burden of proof. And that is Lord Justice Hooper in EA and BA.
Probably wise to look at the wording of section 136 before we look at what people say about it.
Let's do that. It's tab 3. And it's page 21 of the authorities bundle. If there are facts from which the court could decide, in the absence of any other explanation, that a person A, in this case that's Enfield, contravened the provision concerned, the court must hold that the contravention occurred. But subsection 3, subsection 2 does not apply if A shows that A did not contravene the provision.
So what I need help with is how your generic evidence shows that the court could decide, in the absence of any other explanation, that Enfield contravened the provision concerned. I can see that there may have been contraventions from that evidence of the provision concerned, but how do you show that Enfield breached it?
We take the national picture, which is in the EHRC.
Got that.
Which is exactly what my Lord just said. We then take Enfield's acknowledgement that nationally the number of disabled households on the waiting list are applying, taking the point that that's not entirely, the full context of that is not there. We then, on the evidence that Her Honour allowed, the remaining part of that is my client's weight.
Your client's weight has got nothing to do with Part 6. Your client's weight was because, rightly or wrongly, an officer in the housing department of Enfield said it was suitable and it wasn't suitable. And then things changed and he had a second child and so on. The fact that somebody failed to comply with their duty under Part 7 doesn't tell you whether you are waiting longer because of any contravention in relation to Part 6.
No.
It says there was illegality, and that's why you won.
Yes, and one of the things my client's case shows is yes, absolutely, is illegality, and the fact that he was living in unsuitable accommodation. we point to the unsuitable in terms of the degree of disadvantage.
But,
But
if your
we
client
say
had got
that
the suitable accommodation on day one and there wasn't the 20-month wait, it would make no difference to
No.
Part 6.
No, it's still...
As opposed to failing to get the suitable accommodation on day 20-month plus.
Yes, so we say, and indeed, my client's wait in one sense has not come to an end. He was never offered Part 6 accommodation. One doesn't know how long he would have had to wait. But we say that there is the inference sufficient for what Section 136, when one knows about the national picture, that should apply to Enfield.
Sorry,
And there's nothing that suggests it should not apply to Enfield.
when you're doing Part 6, he got his 200 points
Yes,
from the day that the duty was accepted.
from February, yes.
Yes. There are arguments as to whether it's suitable or not and whether Part 7
Yes.
has truly been met.
Yes, no,
But it's hard to see how the Part 7 dispute, was it suitable or not? Did it need to be an extra room before or after the charge was brought? It's difficult at the moment to see why you say that is evidence for the purpose of Section 136 to prove a contravention in relation to something else.
No, the weight is evidence, not the conditions in which he was living, but the weight is evidence.
The
We
weight
then
is
say
the
the
result of an
conditions
error.
go to the form of disadvantage.
But the weight is due to the error in the application of Part 7.
The weight for Part 6, I'm not sure it is.
He would have been waiting
He'd been
Part
waiting in
6.
any. I think we
whether
can,
they got a
I
suitable
agree.
accommodation or
Yes,
not.
yes. No, I agree. So he would have been waiting.
So we know that somebody who gets Section 193 duty might still wait 20 months.
Yes,
Right?
Yes.
And that's it, is it?
yes. The issue is his weight as a disabled household, disabled homeless household. As it happens, Mr. RR was also waiting in unsuitable accommodation. But the issue is weight, and we say that the EHRC national picture makes it clear that disabled people generally, and we infer therefore disabled homeless households, are waiting longer than non-disabled people. That there is no reason to assume, sorry, that's badly put, there is nothing in the papers that suggests Enfield is different to the national picture.
I know that, and you said it before, but it seems that it doesn't enable the court to decide that Enfield contravened the provision to know that there are councils throughout the land who will have contravened the provision because of the number of homeless disabled people. That doesn't tell you, logically, anything about what's going on in Enfield. Now, you may say, well, in the absence of any other explanation, Enfield could have said, this doesn't apply to us, and they didn't say it. But my problem is with the words could decide, because, I mean, obviously if there were another explanation, it's fine, but you don't get to first base, do you, with the could decide from generic evidence. I mean, I'm asking rather than telling, but it seems that a court has to decide on a burden of proof, and the section is all about the burden of proof.
Yes.
So you have to ask the question, could the court decide, if this were the only evidence, that Enfield had contravened the provision, to which the answer must be no. It might be, but it might equally not be. So it is not established on the normal civil burden that on a balance of probabilities, the fact is true.
Well, we have the national picture. We move then to Enfield, and we go to their equality impact assessment, which is all that we have. Sorry, page.
Starts at 413.
Yes, and the disability is at 416. And as I say, our difficulty is that it's all that we have. But what we do see from the about a page, just over a page, dealing with disability, is that Enfield were in 2020 or 2021 wrestling with a problem of what seems to have been, under the old scheme, a quota system, which seems, and Mr. Paget will correct me if I've misunderstood it, that for households who do not require a wheelchair adapted property, again making the point that adapted properties are in a different ring fence, there's an upper limit beyond which residents are unable to bid, and that limit had been met. I read that as meaning there is a finite pool of properties, and we ran out of them in February 2020.
So where's that again? Just
it is at the bottom of the page under the heading "The Current Scheme." So that was a problem that Enfield were wrestling with.
I read that as they, under their own scheme, they put a limit in. They themselves had chosen to limit the number, and that number was reached, and so you couldn't bid.
That's probably a better way of reading it.
That's
yes.
what I read it.
Yes.
And then they go on to say the proposed changes, which is a points-based system, priority residents with limited mobility, various other things,
Yeah.
and so on. And also they got a ring-fenced wheelchair disability adapted properties.
Yes. So
how do you get, reading that as a whole, evidence that the new scheme, which is intended to address disability, is failing to do so?
Because what it does is it addresses it. As I read it, the new scheme then provides an element of flexibility in order to address disability. So Enfield are recognising that something has to be done from the old scheme, and they're doing that by providing the points system, which includes giving higher priority to those who have an urgent need to move due to health or disability reasons. And I read that as both the high health and welfare box, but also the additional preference of medium or lower health and welfare. That's how I read it. It's Enfield's document.
Yeah.
It suggests a degree of flexibility is necessary for people with disabilities.
So where are you reading from again?
The new scheme is based on the assessment of a household lifetime need rather than specific point in time. This will therefore give higher priorities to those who have an urgent need to move due to health or disability reasons. Those with an urgent need to move on grounds of illness or disability will therefore have a relatively higher priority than they do under the current scheme. How I read it, and I may be wrong, is that is both the 1,000 points for high health and welfare, and it's the provision of additional points for low and medium health and welfare. But I may be reading too much into that, I don't know.
Well, either way, it doesn't seem to me to get over the problem that you need to get over, which is to show under section 136(2) that the court could decide that Enfield contravened the provision at the relevant time.
Well, the reason I go to that document is because I say that shows that Enfield were aware of the benefits of flexibility of the point system given to disabled households.
Right.
What that document does not grapple with is why, therefore, disabled homeless households should be excluded from the flexibility provided by the possibility of low or medium health and well-being points.
Just on that question, this family is homeless and they're in priority need because there are disability needs, is that right?
They have children.
They have children.
So I imagine that disability needs were never assessed in relation to homelessness.
Right, okay.
Was there going to be? Sorry.
You know, I just wanted to
That
get
was
the
just-
facts. Yes, that's the question. Yeah.
So I turn to that because I show that Enfield were grappling with what seems to be a problem of the quota for disabled people, meaning that some were unable to bid for 3 months.
So you say they should get 200 points because they're homeless as a family with children, priority need, and if you're homeless with children and also one of the members of the family happens to have a disability,
Yes,
in this case the wife,
yes.
you should be able to add an extra 50 or 150 points depending on how that is assessed.
If you meet the criteria,
Yeah.
absolutely, not automatically.
No,
But meeting the criteria and
you should have the ability to say,
Appendix
well, I
B.
could be homeless plus.
Yeah, well, it's not homelessness plus. Sorry, I came back rather abruptly. It's, the priority need only needs to be assessed in one category. There's no issue about whether or not, for the purposes of the homelessness duty, one has more than one priority need. And it's not necessarily that unusual for a household such as ours.
But no, we're part 7, we're part 6, and you're saying for part 6.
Part 6.
You've got to differentiate between the reasons why somebody's got a priority need, and if it's a priority need because of children, but one of the members of the household also has a disability, you should aggregate those two to work out the points.
Yes, because part 6 is about housing need. Part 7 is getting you into emergency and temporary accommodation. Who are the categories of people under section 189 that Parliament has decided should be accommodated temporarily as opposed to left to fend for themselves. So that's what, and that's the priority need. That's the gate that priority need opens, is into temporary accommodation. Part 6 is about what is your housing need for your long-term accommodation, your home for life, as it were, because it's a secure or assured tenancy and the other benefits of social housing. So it is an assessment of your housing need, and that is not confined to the priority need.
No, I understand that. Yeah.
Where the gate opened, and of course it is, because otherwise a homeless household who had priority needs as a result of children and had a person with disability wouldn't be assessed as needing a ground floor property, but my client and others are. That takes account of the disability, the mobility needs. So I say that the priority need, with respect, is not the point.
Yep, I've got that.
I'm grateful. So back to my overcoming the burden. What I do rely on the EIA on showing that Enfield were aware of the difficulties that the disabled people faced. That's not surprising because we know the national picture on the difficulties that disabled people faced. And Enfield in 2020 or 2021 were grappling with that by introducing a higher priority, and as I read it, the additional priority flexibility, but we're not grappling with what the cap in relation to homeless households, and this EIA doesn't refer to the cap, what the cap in relation to homeless households then meant for homeless households with a person with a disability. And given that they accepted that there was a problem by their change of policy, that they should have done, and that is, again, enough to get us over section 1362.
Okay, thank you.
I reinforce that by referring to both my application and then ground 1, because my application, of course, does, we've looked at the documents, the BBC report and the Ombudsman decision.
We didn't actually look at the BBC. Is there anything I read it?
Well, in that case, can we do so, please? It's page 304.
To see what it actually says. That's helpful.
It's the top of the page, second paragraph.
starts at 302, does it? And this
It
is
starts
something
at
off the
302.
BBC in...
It's a report of, as I read it, a different ombudsman decision, where the council had failed to provide the family with temporary accommodation. My Lord Justice Lewis's point about the breach of duty, and the council's response at the top of page 304. An Enfield Council, second paragraph, an Enfield Council spokesperson said, "We still have a significant lack of affordable housing in London and the South East, and there are but a handful of properties in Enfield that are suitable for those with additional needs." So I rely on that post-hearing, pre-judgment, post-hearing, as saying that is relevant new evidence for this court to take into account. And you have my submissions on the London Marshall test in my skeleton. And that is, I'm sorry, I should have made it clear, that is Enfield accepting the smaller pool, the lack of supply of properties with accessible housing needs. And I say that one can go from that to therefore assuming my disadvantage, which is that disabled homeless households wait longer.
But just working out what this is saying, this seems to be a complaint to the Ombudsman about a breach of Part 7.
Yes.
And this spokesman, if he's quoted adequately and knew what he or she was saying we still have a significant lack of affordable housing in London that is suitable for those with additional needs. That seems to be saying we're having trouble putting people in temporary accommodation.
Well, it's specifically in relation to a disabled mother and son.
Yeah, but it's all
so
about...
we do know there's a disability aspect.
Yeah, but it's about Part 7, is it?
Well, it's not clear whether it's... I mean, the decision was about leaving her in unsuitable Part 7.
Yeah.
But of course, if they didn't have a shortage of Part 6 properties that were suitable for those with accessible needs, she'd have been moved into them. So there's two shortages: a shortage of Part 7 suitable accommodation for those with disabilities, and we say a shortage of Part 6.
Because they'd use the Part 6 to meet the Part 7.
Because they could use Part 6.
Well, they'd have to.
Well, and indeed that's not just have to, but it's the right thing to do, because clearly families in temporary accommodation want to be in Part 6 accommodation as soon as possible. So even in the situation where Enfield's temporary accommodation was profoundly unsuitable for people with disabilities, if we take that, but they had a supply of properties, an adequate supply of properties for people with disabilities under Part 6, she'd have been moved on quicker. So we say that is the new evidence, and we ask you to admit it under London Marshall, is credible evidence that goes to my Section 136 inference.
This may be a question, Mr. Padgett. Within the policy, is there anything that ring fences? So your client's case, for example, she needs ground floor accommodation with a wet room,
Yes.
a shower. Is there anything in the policy that ring fences that for people who need ground floor accommodation and a wet room, so that level of adaptation? Because I think your earlier submission was that was open for bidding by everybody,
Yes.
effectively. So I'm back on my old point of making
Yes.
sure that we're comparing like with like,
Yes.
because I completely understand your case. If you say, well, able-bodied people could bid for the same
Yes.
properties, but they can therefore bid for more than my client can. But some of the material you're showing us talks about adapted properties that might be thought to be much more significantly adapted properties, which you'd expect to be ring-fenced for people who need those adaptations. Do you see what I mean?
The short answer is not that I could find.
Well, there's 48 and 49. The 3.52 says flats on the ground floor may be prioritised for those with medical recommendation for a ground floor. We've got wheelchair adapted properties at 3.6, and you've got specific groups with specific needs on 3.7.
Yes. So wheelchair properties are ring-fenced and allocated by making a direct offer. But I'm grateful to my Lord Justice Lewis at 3.5.2, page 48. the difficulty with that, of course, is that they're prioritised to people with a medical recommendation, but my client's points don't reflect that priority.
No, well, hold on. That's two things.
It is two things,
I've
yes.
got 200 points in the bank. I can bid
Yes.
for 200 points.
Yes.
You say I should have 250 or 350. But part of your argument has been there aren't enough properties, and people who are non-disabled can bid for properties and they'll get them. But if the properties are actually being reserved for those who recommended them for medical needs, then the non-disabled person wouldn't be able to bid for that property.
It doesn't say that.
No, but it does say they may prioritise them.
It says prioritise.
Yeah.
And I read that as the person with the highest number of bids, of points.
Well, that can't be
Wait,
Well,
right.
that
because-
doesn't know that priority is to. I mean, that's. I read that to say where we have ground floor property of exactly the sort that your client needs.
Yes.
We recognise that needs to go to somebody who needs ground floor accommodation.
Mm.
So that would. I mean, I've called it ring fencing, and it may be that it's permissive rather than mandatory, but that is exactly what that is saying. In which case, isn't the problem for your client whether or not she has a medical recommendation for a ground floor property?
Even where it's prioritised, ring-fenced in that respect, then the problem for our client is that those non-homeless households who have disabilities have the potential to get the additional health and welfare.
Yes,
Point.
that's a different.
Well-being.
But that's back to my only point in this case. That's
Yes.
a different comparator group. That's not the group you're saying you've been discriminated by reference to.
No, it's not. No. We're discriminated against the other homeless households. But my point is this, and I know my Lord Justice Lewis is going to come back and say I haven't got the statistics for this, but I'll make the general point. Even then, it's still potentially a smaller pool than homeless households who can bid for anything they want.
Yeah, no, I get that.
Now, even if a homeless household bids for a ground floor property and then a second floor property and a third floor property and is not considered for the ground floor property,
Yeah.
my client can't make those three bids. My client can only make the first of those bids and has to continue bidding for the ground floor properties.
But with 3.52, there are two things. Is this the property for which I can bid? And if so, how many points do
Yes.
I have?
Yes.
If it is a wheelchair adapted property and I didn't need to use a wheelchair, I wouldn't be able to bid for a wheelchair
No.
adapted property.
No.
And the impression with 3.52 is that a proportion of, or a number of ground floor flats would be kept for those with a medical recommendation. So somebody who didn't have a medical recommendation, somebody who didn't have a disability calling for a ground floor flat, wouldn't be able to use their points to bid. So it wouldn't matter how many extra points they got. They wouldn't benefit from having those points, or put conversely, people who didn't have those points wouldn't be at a disadvantage as against them.
So two answers to that. One is yes, if that's the implication of the policy, and I don't know. The other point, which I was trying to make to my lady, is that if my client is confined to bidding for ground floor property, or my client is obviously confined to bidding for ground floor properties,
All properties with lifts. I mean, the thing is, we are getting very granular because, you know, she could manage a third floor property as long as it hasn't got a long flight of stairs.
yes, she's assessed as no more than one floor
Yes,
with a lift.
So,
But yes, level access is what's said. If my client is confined to bidding for ground floor properties, then I think I was trying to make this point to my lady. A certain number of ground floor properties will come up for which he bids. More properties come up, obviously, that are not ring fenced in the general needs, for which homeless households can bid on the 10th floor.
yeah, I'm getting a bit
properties with
twitchy at
steps,
this point
etc.
because that feels quite assertive to me because it isn't. I mean, looking at the reality of your client's situation, it's ground floor would be good, but lift access is permissible. She can manage one flight. Is that right? That's how she's been assessed.
It's assessed one flight with a lift, I think.
Okay.
I'll take you to the OT.
Do you have her assessment of, because that would be helpful, because
Yes. Now the assessment was in one of the properties that was unsuitable, and it starts at page 14. And at page 15, under diagnosis and prognosis, we can see the effects of the car accident. And then the final paragraph under that heading, second sentence, she reported experiencing intense pressure and pain in her legs, lower back and pelvis, legs cramp, which cause her legs to shake uncontrollably. This can cause her to lose power in her legs and fall. And she has reduced power and strength in her left arm. So and then at page 16, we have mobility.
is this, just to understand this
And the
before,
assessment, I'm sorry.
is that her statement of what she needs, or is this the assessment of...
This is the assessment by the occupational therapist. If you start at page 14, it's headed occupational therapy housing report.
Yeah. Mine was a slightly different point. Are they just recording what she said before they reach an assessment?
Well, no, they come on.
Yeah.
Page 18, under the heading housing requirements, a 2-bedroom ground floor property. And over the page, a property.
Sorry, what page were you on? I've missed that.
Sorry, 18 and then
Thank you
19.
very much. Thank you. Yep.
And I was wrong about first floor. A property with level access, both front and rear, or just one low step. A property with a level access shower. And then, second paragraph under summary, it's strongly recommended that the family remain in ground floor accommodation with a wet room.
So I'm just catching up. Housing requirements, a 2-bedroom ground floor property, a property with level access, or just one low step, and either a shower or the possibility of having one under a disabled facilities grant.
Yeah.
Right.
There is, Mr. Paget may take you to it, and it's, we exhibit it as part of our response to Mr. Paget's application that the appeal be dismissed. There is a note of a discussion about the OT report, but which is for my lords and my ladies' notes on page 346. It's all about washing. So I don't think that changes anything. So she's ground floor, which brings us to 3.5.2. But even then I say, and I know my lord will say there's no statistical evidence for this, it must be that the pool of properties that her husband can bid for is smaller than the pool of properties a non-disabled homeless household can bid for, even if the non-disabled homeless household is excluded from bidding for the ground floor properties.
The pool of properties is lower, is smaller for this person than who?
Than a non-disabled homeless household. You don't need ground floor, even if they're excluded from ground floor. And I take that from the national picture of the supply of accessible
The
housing.
difficulty that I've got is this. If the medical recommendation for your client is ground floor, and if they are prioritising people with a medical recommendation for ground floor, she's not being put at a particular disadvantage by the fact that other people are able to bid for floors 2 to 10. She's put at an advantage if they are prioritising ground floor for those with medical recommendation. But non-disabled people wouldn't be able to bid for that, and she doesn't want to bid, and indeed medically wouldn't be appropriate to bid for 10th floor flat.
But we...
Do you see my difficulty?
I do see the difficulty, but if there is a smaller pool of ground floor, taking the point that I haven't got the statistics for that.
If a smaller pool of ground
floor.
But if ground floor is ring fenced for people with a disability, you then need to look at a smaller number of homeless disabled who are eligible to compete for that ground floor flat, if 3.5.2 operates as we think it does.
But if there are fewer ground floor properties, therefore there's a smaller pool, then they still are, their potential for a Part 6 bid being successful is lower
Not necessarily.
than
because
that
if you
of
have
homeless
few-
households who are bidding willy-nilly.
No, I don't think that follows. No, that doesn't follow, because you'd need to know how many people are eligible to bid for the ground floor. In other words, how many people are direct comparators or in the same boat of needing a ground floor flat. If they are ring-fenced, these ground floor flats for people with mobility problems, you can't assert that there are fewer, that your prospects of getting one are less. There are fewer you might be able to say there are fewer ground floor flats than there are other non-ground floor flats. You might be able to say that.
Yes.
But what you then got to look at is how many people are in the eligible pool to bid for each sort.
Yes.
And
And we don't have those statistics because, of course, they are in Enfield's possession.
Yeah, but you can't draw the inference. I think I'm just saying you can't draw the inference that you were just inviting us to draw.
No, I understand that, and I come back with the low standard of the low burden of proof on that it is an inference.
I'm wrestling with a different problem, which is I don't see, because there are 4 stages, it's got to put the person at a disadvantage. The PCP must put the person at a disadvantage. And the fact that non-disabled people can live on the 10th floor, the 20th floor, but and therefore can bid for all the flats, but your client can only bid for the ground floor one, and that may be ring-fenced for people with medical recommendation. She's not put at a particular disadvantage by the PCP in respect of bids for floors 2 to 20, because she can't bid for floors 2 to 20 because they're not suitable for her, because she's had a car crash and the doctors have said, no, you need to be on the ground floor.
But that's why, in comparison with homeless households, that disadvantage that she's suffering needs to be recognised.
What does that mean?
Well, what that means is that the capping of points for homeless households is ostensibly a neutral provision, as Mr. Padgett says. It applies to all homeless households. But it affects, we say, disabled households to a particular or substantial disadvantage. And so we then go on to say that disadvantage needs to be remedied.
But if they're ring fencing or prioritising ground floor flats, so the non-disabled don't have the ability to bid for them, whether you put it as poor, as my lady says, or being put at a disadvantage, it's to do with her needs, not to do with the policy.
If they are, and it's hard to know how to read the word prioritisation there. My lords and my ladies, I think, we've explored it.
I was just going to say the very same.
I'm grateful. Can I just remind you of the heads of my submissions in the skeleton argument? The first is that we draw attention to the authority of Warden Hillingdon, which is in tab 9. Which I know my lords and my lady will be very familiar with. And we draw attention to it in 2 respects. One is the point that a policy can be lawful under Part 6, but it could still be a breach of the Equality Act and therefore unlawfully discriminate. Lord Justice Lewison makes that very clear. And the other point in Warden Hillingdon, my lords and my lady will know that was about a residence requirement, which, after some refinement, had the effect of those who could not fulfil the resident requirement being in a lower band, and Lord Justice Lewison makes it clear that as a result of being in a lower band, their chances of being allocated under accommodation, being allocated Part 6 accommodation was reduced, and that was a relevant disadvantage. So we've been considering the figures, but I make the point that if I'm sufficient for Section 136, then it's having a reduced chance of being allocated Part 6 accommodation is a disadvantage under the Equality Act. I've made my point about the application in respect of the 2 new pieces of evidence under Ladd and Marshall, and I say that if the information, the evidence in front of Her Honour was not sufficient for Section 136 and the inference, then those 2 new pieces of information, one should be admitted, and certainly the BBC report is sufficient.
And is the BBC report on the second one is, just remind me?
The Ombudsman.
Oh, the Ombudsman report, yes.
And specifically, it's not the report, it's not the decision of the Ombudsman. It's what Enfield said. Yeah. But that's about
What page
unsuitable
is that,
accommodation rather than lack of disabled accommodation.
Could you give me the page number where Enfield speaks about the Ombudsman report?
Yes, it is, sorry, page 312.
Thank you.
On ground 1, we say that Her Honour was wrong to admit 3 additional pieces of evidence. Those from Shelter and the All-Party Parliamentary Group go to the standard of accommodation in Part 7 accommodation. So that's us making the point that Part 7 accommodation is disadvantageous as compared with Part 6. And specifically, the All-Party Parliamentary Group at page 270 talk about serious accessibility issues in temporary accommodation. And we also asked for the freedom of information response that we've looked at page 300 to be before Her Honour. She refuses that application. And we say in that she says that they didn't add anything to my client's case. We say that those documents were sufficient once what was before Her Honour and was admitted, we've gone through this, was my client's account, the EIA and the EHRC report. We say that those, if that wasn't sufficient for Section 136 to be made out in itself, then those 3 documents were, and that they were the something more that's referred to in authority, specifically JACU and Network Rail.
Just to get the facts right, you hadn't put them in with your evidence when you made your claim. You produced them at the hearing, did you, or before the hearing? But it wasn't part of the evidence that you'd put in as part of the claim. Otherwise, it would have been there.
I think that's right. Would you want to give me a minute? Right. There was, I'm told there was an application after the claim was filed, but at a relatively early stage. I can check the date for my lord. So we weren't ambushing. That's in and we say that Her Honour's decision to exclude those documents meant that Mr. Bano behind me was having to argue the Section 136 inference with, as it were, one hand tied behind his back. Of course, I have to be careful with that submission because that's my submission on ground 1, but on grounds 2 and 3, I say that Section 136 is made out on the evidence before Her Honour. And we have gone through that. All I would do is draw your attention to the 3 authorities on Section 136, EA and BA, where Lord Justice Hooper paragraph 34 sets out the principles governing the predecessor to section 136, and then at paragraph 52.
Hold on, we haven't got tabs, and the index doesn't have page numbers.
Oh, I'm so sorry.
It's taking time to get the right.
I'm so
I've now
sorry.
got it.
I
What
thought
are the
you wanna-
paragraph
I thought my
numbers?
notes had both.
No, got neither, in fact.
That's
Um,
noted. EA and BA is, I was going to say tab 5. Not entirely sure how to help you.
I've
Comes
located
up-
it. You've got to look at the index and have a stab at how far in it is.
Page 35. the
Yes,
electronic.
page 35. There are page numbers on
Oh,
the
there are
pages.
hidden actually. Yes,
Yes.
okay.
Yes.
So, and it's which paragraph?
So there are 2 paragraphs, page 40 in the bundle. Paragraph 34 sets out the principles of the burden of proof as it was then under the Sex Discrimination Act. And paragraph 52 is which is page 43, is where Lord Justice Hooper makes the point about what's now section 136. If an employer takes a stand adopted by the respondent, namely you prove it, claimants, particularly those of limited or no means who challenge large corporations, will be at a great disadvantage. And we say that's all in respect of the employer choosing not to call evidence and inferences from that. But we say that obviously applies where what is relevant to us having to discharge the burden, an ordinary burden of proof, is the statistical evidence that we've been talking about, and that is in Enfield's possession. I don't need to ask the court to look at it, but I'll draw attention to the other authorities. The Supreme Court in FOB and Royal Mail, which is page 267 in the bundle, considered the wording of section 136 under the Equality Act as against the wordings under the Sex Discrimination and Race Relations Act, and Lord Leggett concluded that the law had not changed. And then
So which paragraph is that?
that is the conclusion that the law has not changed is at paragraph 34, which is at page 279.
Yes.
34 has not made any substantive change in the law. And then the most recent authority from the Employment Appeal Tribunal is JACU and Network Rail, which is page 366 from the President. This is Justice Eady, and she summarises Lord Leggett in a FUBI at page 385, and at the bottom of page, sorry, she summarises from the bottom of page 386 onwards.
So 386.
386 and 387. And then she notes at the top of page 388, the assessment under section 136 of the Equality Act is for the Employment Tribunal as the first instance tribunal of fact. And Mr. Paget makes the point that this was an evaluative, Her Honour's decision on 136 is an evaluative decision made by her, but of course we are in judicial review, we're not in an employment tribunal having heard witnesses and so forth. And so I say that point has less substance when the documents that were before her is also before this court. Mr. Paget makes the point that this is a neutral provision, and to a certain extent we've gone through that. I make the point in respect of indirect discrimination and about what Baroness Hale has to say in ESOP and the Home Office, where she talks about the significance of indirect discrimination being about achieving a level playing field and recognising that there are hidden barriers not easy to anticipate or spot. We say that the hidden barriers here are the lack of accessible housing, and that level playing field should either be justified as towards the beginning of the Sex Discrimination Act, a height requirement in the police, for example, was said to be justified, even though it had a disadvantageous effect on women. Could either be justified, and if it's not justified, then it is indirect discrimination. So that's in respect of grounds 2 and 3. In respect of ground 4, Mr. Paget obviously has his appeal, and he says that there was no duty under the Public Sector Equality Act under the Public Sector Equality duty to monitor beyond what Enfield had already done in the Equality Impact Assessment. If necessary, I'll come back on that, but I just point out that the Equality Impact Assessment in itself did say that Enfield would monitor.
But one needs to be precise. Section 149, in the exercise of its functions,
Yes.
you challenged the initial policy, the revised policy, and you challenged the decision made on the basis of that policy. So you weren't saying that the allocations policy failed to have due regard when it was adopted, and there hasn't, it seems, been a claim that the exercise of functions in the taking of the decision involved failure to have due regard. What there seems to be said is that there is a freestanding duty, presumably enforceable by mandatory orders, to monitor. And I don't at the moment understand where that comes from, separate from, for example, getting facts, so you've got in everything for what you need the next time you review the policy, or why the fact that going forward you need to make sure you collect statistics, how that is material to the allocations policy and the decisions taken under it.
Well, because the Equality Impact Assessment in itself, bringing in the 2020-2021 policy, is, first of all, it says that it will monitor.
I understand that, but I'm asking about the functions that were exercised, which was the adoption of the allocations policy, and which was the decision, and it's the Section 149 duty, not the practice that the Equality Impact Assessment said would be desirable. So why is the alleged duty to monitor, if it exists, material to the adoption of the policy and the decisions taken under that policy?
Because the decision that my client couldn't be awarded extra points, 23rd of May 23, at that point, Enfield had the clear point from us that the exclusion of disabled homeless households from the possibility of additional preference was discriminatory. You haven't got the letter of representation that led to that decision, but we can see from the review decision that it's responding to that.
So I haven't got the facts clear, and I'm not sure that we're having the same
I'm so sorry.
Can we just start, please, with the allocations policy?
Yes.
Full stop.
Yes.
There'll be a new topic in a minute. How can any breach of any alleged duty to monitor be material to the adoption of the allocations policy or its revised policy in 2022?
Because, as Lord Justice Lewison makes clear in Ward, where there is a trigger that, and I'll need the exact words from Ward, and I was going to say it's tab 9. I'll give my lords the right page number. Sorry. It's tab. It starts at page 145. And Lord Justice Lewison is making the point that
Which paragraph?
I'm just finding it, that page 169. Hillingdon submits at paragraph 72 that in formulating the policy, it's not incumbent on the policymaker to assess the potential indirect discriminatory effect on every conceivable group that shares a protected characteristic. I consider that there's considerable force in that submission. And the examples given of my
So which paragraph? Did you see 169? I just can't find it.
paragraph 72.
72, sorry. Yeah, sorry, I've got it now, yeah.
Mr. Rutledge submitted. Yes, yes. And the examples given of whether or not they should consider the resident requirement on Native Americans or Australian Aboriginals. Lord Justice Lewison accepts that. It may well be the case that in formulating a policymaker has conscientiously attempted to assess the potential indirect discriminatory effect on groups sharing protected characteristics, but has reasonably and in all good faith overlooked a particular such group. It would need to be shown that the policymaker had given adequate thought conducting such inquiries as might be necessary to decide which particular protected groups ought to be considered. But if, having done so, a particular protected group was overlooked, I do not consider without more that would amount to a breach of the PSCD.
So going back to the allocations
Yes.
policy, was the allocations policy, how could that be rendered unlawful or materially wrong by a failure to monitor the consequences of the policy?
Well, what was overlooked in the equality impact assessment is the position of disabled homeless households.
No, it's a specific question. Is the allocation policy unlawful because of a failure to monitor?
What I'm saying is that there is a trigger after which Enfield should have been having due regard or at least monitoring it in order.
Had the trigger been pressed, if you
So,
prefer
yes.
that, at the time?
Yes, so I accept it's possible the trigger was not pressed at the time of the EIA. I draw attention to the omission in the EIA, but I accept it's possible the trigger was not pressed then. What I say is that the trigger was clearly pressed by May 2023, when the point is being made on behalf of my client that disabled homeless households are in a disadvantageous position as against homeless households.
So a lawful policy suddenly becomes unlawful because of knowledge about a particular case.
A potential omission, yes, and that is the case in Warden Hillingdon,
Well, that's
where-
in paragraph 74.
and that's in paragraph 74, where when the position of refugees or Irish travellers was drawn to them, and they did, in fact, reconsider, but they failed to consider those two.
But that seems to go to reviewing the policy, and it may be that if you haven't monitored, if you know there's a problem and you haven't gathered the statistic, how when you review the policy and adopt the new one, when you've got the new one, can you be sure that you've had due regard when you're formulating the new policy? I'm having trouble with how the duty to monitor, which you claim exists, and which the judge found existed, which would produce statistics over time, which didn't render the policy unlawful, you accepted, could have rendered the decision under that policy lawful, as opposed to, well, we know there's a problem now, this case is saying there's a problem, when we review our policy, we might or might not be vulnerable if we don't make sure that we have the information available to show we've done due regard.
Which they didn't, and I say they are vulnerable for that reason, but I take the point that the judge found it in much more general terms, that there was an ongoing duty to monitor.
Just remind me, we've moved on to the allocation policy now. Which decision are we challenging? It's the review decision, isn't it?
It's the review decision of
And just remind me of the date.
23rd of May 23. And that
So-
was, sorry.
That's the one where Mr. Lyons, I think, sent representations. So if you're saying in May 2023 that there's a problem, and you're saying therefore you should start monitoring to see if you've got data, you've applied a lawful policy, you've got somebody saying there might be a problem, so you need to check the data. How can that make the decision under challenge unlawful because of a failure of a duty to monitor?
It makes Enfield in continuing breach of the Section 149 duty.
We're talking about the decision. You had the decision unlawful.
Because Enfield, having received the point, and first of all, we say they should have noticed the point in the EIA. but on the basis that it was lawful for them not to notice, as per Ward, Enfield, having received the point, could not comply with the public sector equality duty without monitoring, and
In
therefore,
exercising its functions is taking a decision. So is your submission
and therefore the
they could not
decision-
take a decision in May
Yes.
2023?
yes, yes. And then on
Without
remedy,
they
so-
couldn't take the decision without doing what? I mean, what I don't understand is how the monitoring fits in with the alleged illegality of the decision.
because had they properly complied in May 23 with the Section 149 decision, then they would realise that they had to inform themselves about the facts and the statistics and so forth in order to comply with Section 149. And that is in DXK, which starts at page 397.
So
397. Did you say?
397. And at page 429, my lords and my lady will know that this is a judicial review on the Home Secretary's policy in relation to pregnant and new mother asylum seekers.
Well, so what I've got at 397.
DXK and Secretary of State?
Sorry?
DXK and the Secretary of State?
Oh, I see, we're in the authorities.
I'm so sorry, I should have made that clear.
Sorry.
So going back to the Act, in the exercise of functions, the function was to take a decision on allocation, which they must do in accordance with their policy. And you've told them there might be a problem and you need to gather information. And indeed your policy might have to change because of the information. How is the exercise of functions comprising the taking of a decision in accordance with the existing policy affected by the need to obtain information?
Because Section 149 duty is a continuing one. If my lords and lady turn to page 428, then there is a summary of the principles under the PSED. And at the top of 429, Roman numeral 5, the duty is a continuing one.
Yes, you need to understand what that means. That's bracketing the disembodied statement, and there have been other cases saying you need to be careful about context. If you're dealing with an allocations policy, for example, it's not a continuing one because it's been done and the time limit runs from the time that it's been done. So saying it's continuing simply means there are circumstances in which things are required in the exercise of functions.
Yes, yes. We continue at 6, the point that it's a duty of process and not outcome, because good processes are more likely to lead to better reformed and better decisions, and whatever the outcome, good processes help to make public authorities accountable to the public. At 7, the duty is not simply to have regard, it must be due, and that's a proper and conscientious focus on the statutory criteria. And further down, Lady Justice Rose, the duty is a flexible one. What is due regard in one case will not necessarily be due regard in another. It will vary perhaps widely according to circumstances. And at 8, a decision maker must have due regard to the need to obtain relevant information in order for him properly to discharge his Section 149 duty. And that's then considered from paragraph 134 onwards. And quoting from Brown, the public authority will, in our view, have had to have due regard to the need to take steps to gather relevant information in order that it can properly take steps to take into account disabled persons' disabilities in the context of the particular function under consideration.
Sorry, paragraph. Can you just give me that para again that you were reading?
Sorry, paragraph 134 at the bottom of page 49. And at 136, Mr Manknell is correct that the duty to gather information is akin to the common law 10-side duty, reviewable according to the Wednesbury standard, but that's not the end of the matter. The duty derives by necessary implication from the statutory duty to have due regard, albeit informed by common law. The discretion as to what information should be obtained is not at large. It is conditioned by the nature of the Section 149 duty and its statutory obligation, as well as the EHRC Code of Guidance, as well as the facts of the particular case. And then we have the EHRC guidance at paragraph 137, which includes, quoting from it at paragraph 518, a body subject to the duty will be able to, and if we go down to in italics, decide whether to modify or reconsider a policy, practice or decision. And then two bullet points further down, monitoring their progress against these objectives. Monitoring the progress of policies and decisions will enable the body subject to the duty to address the continuing nature of the general equality duty. It will need to decide how to review progress proportionately, so it's aware of circumstances which could require it to consider reviewing a current policy or decision. For example, equality evidence could show that the community it serves has changed, the context in which the body operates has changed, or that the policy is having potentially discriminatory practice. And 519, that does not imply that a body subject to the duty needs in every instance to have hard statistical data. So we do say that if the trigger was not in the EIA, then it was when we made representations leading to the decision.
With the consequence that either the decision is unlawful or that no decision could be, well, I don't see how they're going to do it, because they've got to take decisions to get the data.
This decision is unlawful because they failed to have regard to the public sector equality duty. And in order to have the not regard to the duty, is that they failed to apply the duty so as to have due regard. And in order to have due regard, we say it would have been necessary to monitor. We might be wrong on what exactly they should do, but we drew what we say is the disadvantage between disabled homeless households and non-disabled homeless households to their attention, and that was sufficient for the due regard duty to be triggered. But in fact, Enfield did not monitor or reconsider, or indeed say in the decision that they had regard to the public sector equality duty. And therefore they can't show on those facts that they had due regard.
That's not the appeal, though. The
Sorry?
appeal is just about the monitoring, isn't it? Oh, sorry, the appeal is about the remedy for failure to monitor.
Well, our appeal is about remedy, yes.
So what remedy do you say could have happened? A quashing of the decision?
Yes. A quashing of the decision, a declaration that there was a failure to comply with Section 149.
You want to quash the decision and declare a breach of 149.
Yes.
A mandatory order requiring them to monitor?
It's very much for them as to how they comply with Section 149. I'm not against a mandatory order requiring them to monitor, but I don't think that was in our claim, and I don't think I could pursue such a thing. Our point is that they have acted unlawfully. It's not for us to tell them.
Yeah, so the decision must be quashed and the declaration
Made.
Failed to monitor.
A failure to monitor and a failure to have, by May 2023, the review decision is tainted, is unlawful, because the point is being made about discriminatory impact. That's the trigger as per Ward. And Enfield take no steps to have due regard and to consider what they need, the gathering of information under DXK, in order to have due regard. Mr. Paget relies on, as he did below, on Section 31, subsection 2A, that it's highly likely that the outcome for my client would not have been substantially different if conduct complained of had not occurred, and we say that there was no evidence to that effect. We draw attention to the high threshold at Plan B Earth, which is in the bundle of authorities. And we also draw attention to AK and Westminster, which is at page 451 of the bundle of authorities, where the administrative court, having had such a submission, say it's impossible to know what determination there would have been when there was no compliance with the public sector equality duty. So we say that it's not possible for Enfield to say that. Enfield says, in relation to section 31, subsection 2A, context is all, and rely on the case of Gathercole and Southwark. And we agree that context is all. And looking at the case of Gathercole and Suffolk, I'm too used to dealing with London local authorities, Suffolk, we point out that there had been a considerable number of reports in that case that considered issues about noise on children. The only omission was to consider noise on children with protected characteristics, but Suffolk had gathered the information. So although there was a breach, then section 31(2)A applied. Would my lords and my lady give me a minute? If just have a moment. Right. If I can deal with, I've got four short points. The most practical one first is to say, in terms of Ground 1 and the shelter and the APPG reports, they were served 7 weeks before the skeleton arguments. Can I just come back to the test on indirect discrimination, and Baroness Hale's remarks in ESOP and the Home Office at page 138 of the authorities bundle. And it's back to this point about that the disadvantage, such as there is, the underlying reason for it is shortage of accommodation.
Which paragraph?
So I'm on page 138, and it's paragraph 26. A third salient feature is that the reasons why one group may find harder to comply with the PCP than others are many and various. Context factors. They could be genetic, such as strength or height. They could be social, such as the expectation that women bear greater responsibility and so forth. The point about a PCP which results in particular disadvantage, there may well be a social reason for it, a context. But if the claimant shows that disadvantage, shows that there is a PCP, and that PCP puts them and others with those protected characteristics at a particular disadvantage, then the playing field is not level. That's not enough for indirect discrimination, as Baroness Hale goes on to say at paragraph 29 at the bottom of page 139, because it's always open to a respondent to justify the disadvantageous PCP under section 19, subsection 2D. And indeed, where the disadvantage has the context of social factors, such as a lack of supply of accommodation, accessible accommodation, then justification may well apply. But we haven't got to justification here. We're still grappling with whether or not I can make out disadvantage for the purposes of section 136. So the underlying reason, the social context, is not relevant to section 136.
I don't really understand that point. because the PCP here is the practice or policy not to allocate extra points
Yes.
for disability.
Yes.
So how can the disability then automatically, obviously, which make it harder to comply with that policy? I mean, it's not logical. The policy is the failure to allocate extra points,
Yes.
and of course, people who are disabled may find it harder to get accommodation, but that's not the question when you are comparing the two groups we've discussed endlessly this morning.
I was anxious to ensure that the social context, the very severe housing crisis that we all understand, is not a reason for failing to apply the very clear analysis of Baroness Hale in ESOP about whether or not there is discrimination, whether or not a PCP is disadvantageous.
Yeah. Okay.
Yes.
All right. Well, I get that.
And can I make a very final point, which is the...
You said you had two more, but I'm
I've-
reduce it to one if you...
I'm going to have one more, which is the interpretation of 3.5.2, the ground floor facts, in the allocation scheme. And that's a matter of course that has been raised by the court, and I'm very grateful for that. That's never been Enfield's case. It's never been. Enfield's case has been that they can overcome any disadvantage by my client applying to the emergency and exceptional panel and being made a direct offer. But their case has not been that there is a ring-faced set of ground floor properties and that prevents any disadvantage. And again, I'm back to section 136, that dealing with this, all the statistics about whether or not the overall pool of people suffer longer waiting time or have fewer opportunities to bid, those statistics are in Enfield's hands.
Yeah.
Is there anything else? My lords, my lady, those are my submissions.
Thank you very much. Thank you very much. Mr. Paget.
Well, can I make two introductory remarks before dealing with the specific applications on whether it's an academic appeal and the grounds? The introductory remarks are these. The Supreme Court in Aphobi tackled section 136 and concluded it was the same test applied as under previous legislation. And it said what you can't do is merely assert discrimination. What is needed is proof of primary facts from which the absence of an explanation and an inference of discrimination could be drawn. That's paragraph 15 of Aphobi. And that's exactly what's happened in this case. There's an assertion of discrimination under the PCP, and if the appellant wanted information in relation to support that, to be able to get over the section 136 hurdle, they could have made a freedom of information request about the implementation of the policy under Part 6. They didn't. They've asked all the wrong questions in their freedom of information request, which I'm not sure whether it pertained to this case or was generally made by the law centre of the local authority. What it has garnered, both in evidence that was before the judge below and subsequently in the applications for more evidence. There's lots of evidence about how awful it is for certain categories of people under Part 7 accommodation. And secondly, much more general evidence about the social sector as a whole and how difficult it is for certain categories of applicants to obtain accommodation that is suitable and that they like. So that's evidence in a sandwich. That's evidence either before the PCP applies in relation to if you happen to be owed a Part 7 duty, how it is performed by local authorities, and how allocation policies take a long time to generate and allocate appropriate accommodation to certain groupings. That's at the end of an allocation policy. There's no evidence at all about the PCP that was being challenged in this case. The second introductory remark is to draw a distinction between what is social housing, what is Part 6 and what is Part 7. A lot of the reports go to social housing, and Ms Davies' submissions were including social housing at large. That is public sector housing, covering both local authorities and housing associations. Part 7 accommodation is a subset of local authority accommodation, and likewise is Part 6. So we need to be very rigorous when looking at reports that they actually bite on what's relevant for this challenge to this application.
So you said Part 7 is local authority accommodation. I'm not quite sure the distinction you're drawing. I understand that social housing in Part 6 covers local authorities and housing associations.
Yes. And then,
what's your point about Part 7?
well, within local authority accommodation, there's two subsets. There's Part 7 accommodation, which is provided under Part 7, and then Part 6. So we need to be rigorous in looking at what is relevant to a PCP that deals with Part 6 accommodation only. This appeal is academic. The applicant, appellant, was provided accommodation under Part 7, and so consequently what has been removed from the housing register.
But the argument against you is that he's got an appeal on suitability, and if he wins that, he'll be back on the register. So until we know about that, the outcome of the appeal, we don't know if it is academic.
That is correct in relation to if it ever is in the future found that the accommodation offered is not suitable. But the presumption of regularity applies as of today. The local authority has removed the applicant in compliance with the allocation policy at 9.11, which is at page 61 of the supplemental. We will remove applicants from the housing register if they are a homeless applicant who became homeless after November 2012 and has been made an offer of private rented accommodation, rented home. So that is right, my lord, that the appellant might successfully review at some stage in the future, or more likely might pursue a county court appeal, but that's going to be a year in advance of where we are now. What he has been provided with is at one with the occupational therapist report that we looked at.
But if the appeal succeeds, what happens? Is he then treated as not having a private sector tenancy that brings the duty to an end. If the appeal succeeds, is it recognised that the Part 7 duty continues?
Yes, that's right. There would be a Part 7 duty owed to provide suitable accommodation under Section 193. And because that is owed to him, he would be entitled to go onto the housing register under this category.
What happens to the period between the lodging of the appeal and the outcome of the appeal? Is he treated as having been on the register? For
that period, yes. Because the decision is quashed, so it would go back to as it was previously. The duty has been owed throughout that period. So time on the housing, on the allocation policy would continue as well.
Right.
So what happens if we say this appeal is academic, and then his appeal, his other appeal as to suitability succeeds? How does he get back here to argue the points?
He could make an application under the new allocation policy and to have that determined.
Well, that's a bit unfair when he wants to appeal Judge Walden-Smith's decision.
He no longer has the lease to do that.
The lease?
Yes.
The lease?
The lease. I apologise.
Let's use English, shall we?
My pronunciation. He no longer has the standing to pursue the appeal. Now, it might be in the future, in one scenario of many different factual outcomes, that his position on the housing register revives.
I mean, I don't understand why he no longer has the standing to pursue the appeal. He lost his case before the judge, and he put in a notice of appeal in time, which has been responded to, and you have put in a respondent's notice. The appeal is listed, and we're all here. It may be that the decision will not affect anything, but it may be in another situation that it will. And he will be benefited if he wins the appeal, because he will immediately get the rights that his successful appeal will give him, rather than having to go through some convoluted process of applying under the new policy, blah, blah, and then challenging it if he's rejected. I mean, that's not what we're talking
even
about
if,
with academic.
With one variation on that, my lord, even if his appeal is successful in relation to this appeal in front of you, it will have no effect on him because he's been discharged from the housing register. It only bites if in the future, if he's successful on the appeal, he'll say, oh, look, I can rely on the Court of Appeal decision if he's successful at this, in how you should look after me in relation to the housing register.
He'd be successful in two ways, wouldn't he? One, he'd be successful because he's got the benefit of his appeal to the county court. But secondly, he's successful in that, on this hypothesis, we'll have found he was indirectly discriminated against
My lord,
in the period up to the offer of private sector tenancies. And what you're trying to do is avoid the finding that he's been treated unlawfully in that period by saying it'll all be hanky-dory for the future. And A, it may not be hanky-dory for the future, and B, there's still the question of whether or not he was treated properly during.
Well, my lord, I'll just quickly go through my points.
You've got better points, haven't you?
I've got points that apply it to Salem and to Hutchinson. That this isn't, unlike the Brooks and Islington case, this isn't a situation which revolves around a temporary duty that is often time limited, so warrants the court considering the judicial review in that case or the appeal in this case. The House of Lords in Salem gives clear guidance that academic public law appeals have a very limited scope.
But wouldn't he get damages for the period that he'd been indirectly discriminated against? Not just public law, portion of the decision. He'd get Section 19 damages.
I don't think that was pleaded as part of the
Of course, it was in the claim form.
here, but he could, even if it wasn't, he could bring a claim in the county court for that in any event. What I note about this appeal, in contrast to the guidance given by Salem, is it doesn't involve a point of statutory construction. It doesn't involve
damages in respect of discrimination, actually. He did claim it, to be fair.
Yes. It does involve a detailed consideration of the facts. It doesn't involve a large number of people in a similar situation. Importantly, in relation to the Hutchinson test, the Equality and Human Rights Commission haven't felt the need to intervene in this appeal. They haven't felt the need that this appeal raises anything of general public importance that warrants their expertise. This isn't a situation where the appellant can indemnify the local authority, and because we don't have the EHCR views on general application at this point, it wouldn't be argued fully in front of you, so those principles aren't satisfied either. Those are my submissions on the academic
Thank you.
point. Can I then turn to the new evidence that is being sought to be included in this appeal that wasn't before the judge below?
BBC and the Ombudsman.
The BBC and the Ombudsman.
Yeah.
And to some extent, it doesn't really matter which way you skin this particular cat. This evidence is just not germane to the PCP. So consequently, when looking at the other reports, the judge below was completely right in not including them, albeit we had the ECHR report. And exactly the same points are applicable to the new evidence. But the reason why it doesn't really matter is that even if this evidence was submitted, it doesn't go to the PCP, and it isn't evidence of the discriminatory effect of the PCP. So that's why she was completely right as a matter of evaluative judgment, and there's no identified principal error that she's done that would warrant this court interfering with a clear case management decision.
I mean, the admission of the evidence is a little bit, the big argument about the admission of the evidence is a bit silly, because if we think the evidence is good enough to make their case, we're obviously going to admit it under Ladden Marshall, and if we don't, it doesn't matter whether we admit it because they're going to lose anyway.
Correct.
So we're really dancing on the head of a number of pins which are a complete waste of time.
That's correct.
Which is often the case when people are arguing in the Court of Appeal about the admission of evidence.
That's correct. But what she did below was completely correct. And the new evidence is not any Perry Mason smoking gun. It's just more of the same. What does it say? Well, we've looked at it carefully. It says two things.
We haven't heard about Perry Mason in this court for many years.
It's a good line.
Tragic. One.
It's a good line.
I don't think Perry Mason would naturally fit into this kind of case, but maybe I'm wrong.
Well, we were discussing elements of his vulnerability under the allocation policy itself. We've got wheelchair users that have a specific category. So he might be more interested in this case, even though it's not a criminal case. The BBC report is at S302. And as my Lord Justice Lewis has rightly pointed out, it just relates to a report about Part 7 accommodation. There was an award of £2,300 because the family had been living in unsuitable temporary accommodation, in other words, Part 7 accommodation. And as we've been discussing, there's specific duties that are enforceable, that are not resource driven, so you have to comply and you have to provide suitable accommodation, and if you don't, lots of things can happen to you. Mandatory orders can be ordered against you following Iman and Croydon, but also you can ask for the Ombudsman to give you a bit of compensation for that period, which is exactly what happened here. And as part of that, on page 304, Enfield says, we still have a significant lack of affordable housing in London and the South East, and there are but a handful of properties in Enfield that are suitable for those with additional needs. And that has no probative value onto the PCP, because all that Enfield is saying there is, look at what is specifically referenced, the southeast. So if you have an obligation to provide a certain type of accommodation, ideally under section 208 you provide it within your district, but there's lots of circumstances where London authorities can't do that, so they provide accommodation outside of their district. This says only that. Because we don't have it in our district, we can provide it elsewhere. So consequently, the Ladder-Marshall test is not satisfied. I accept what the Master of the Rolls says, we're dancing on a pin, but the gateway into considering this has not been opened. The same applies to the Ombudsman report, which follows in the supplementary bundle at page 305. Once again, this relates to unsuitable temporary accommodation. Now, Ms Davis says this is an informal term. I would say it's a term of art. Temporary accommodation specific to Part 7, and it is used as that in the housing context. In that report, the local authority say to the Ombudsman at page 312, it's estimated that there are at least 600 houses in unsuitable temporary accommodation in its borough for a variety of reasons. Again, that bites on its Part 7 duties, its obligations under Part 7, enforceability of those following Imam and Croydon. It doesn't in any way assist in finding primary facts in relation to this PCP that show a disadvantage to the applicant. So consequently, again, the Ladder-Marshall test is not satisfied. And the gateway into considering that, albeit you have, it has not been opened in this appeal. It's very much at one with the evidence that is relied on in ground 2 and 3. Let's look and remind ourselves of what the actual test is needed in relation to section 136, which is the ESOP at page 138. Baroness Hale, at paragraph 25, says, indirect discrimination requires a causal link between the PCP and the particular disadvantage suffered by the group and the individual. So there needs to be a tethering of the evidence to the PCP. There needs to be a causal connection between the disadvantage, whether it's substantial or particular, depending on whether it's section 19 or section...
Sorry, which bit of that are you referring to?
In paragraph 25, my lord, on page 138.
Yes, it says direct discrimination expressly requires a causal link
Yes.
between the less favourable treatment and the protected characteristic. Indirect discrimination does not.
Yes.
Instead, it requires a causal link between the PCB and the particular disadvantage. Right, that's the bit.
Yes, exactly. Now under direct, so under direct...
read the whole thing to understand it.
Yes.
Yeah.
Under direct discrimination, it needs to be tethered to the action of the disadvantage. Under indirect discrimination, it needs to be tethered to the PCP. You need to show that the PCP and its implementation of the PCP is causing a substantial or particular disadvantage.
You know, it's often easier to look at the section itself, section 19, and if you look at that rather than what people have said about it, it becomes clearer. Although to be fair, what Baroness Hale says is spelling out the two things as part of B, but at page 17 it's got to be a PCP It's got to be discriminatory. It's
Yes.
discriminatory of A, B, C, and D.
Yes, my lord is correct. You just look at the section, see what it says on the tin.
Yeah.
Alternatively, look at the learning, and the learning is saying to people, tether it to the PCP. Don't just complain about how difficult it is in relation to my life that's got nothing to do with the PCP or what might happen subsequently.
So not enough to say there are particular difficulties, they might be suffered by particular groups. You've got to show the PCP and the causal link and so on. Yeah.
You need to show there's something in the PCP itself that is causing difficulty for a particular protected characteristic group. Inevitably, people that are seeking 4-bedroom properties will spend longer on allocation. And the same may be true of applicants seeking adapted accommodation. But that isn't because of the PCP, that's because of what the allocation policy is trying to do, which is match qualified applicants with properties whenever they become available. That may take an awful long time. It often does. That's not the fault of the PCP. That is made clear by the case of Lynn and Barnett at the Authorities Bundle, page 121, paragraph 25. There it was talking about reasonable preference, which is an obligation that a local authority has to include within an allocation policy to make the allocation policy lawful. Prospects of success depend on many factors, of which the most material is the fact that demand for accommodation greatly exceeds supply. It is quite possible for a lawful scheme to give reasonable preference to a person within section 167 and for that person never to be allocated part 6 housing. Such a person is entitled to no more than a reasonable preference. So of that evidence that the appellant has provided, a lot of it is agreed, it's accepted that that is part of the landscape in which we live. The fact that people spend a long time on the allocation policy is because it's merely a conduit pipe between an eligible applicant and the pot of gold at the end if they're allocated. There is no problem with the pipe in this case. When Ms Davis was being asked questions by the court, she said that there was a smaller pool of properties for certain applicants and then a bigger pool of properties for other applicants, and that's true. But that's not part or the fault of the PCP. And then
She says that the PCP means that some people get through the pipe quicker than others. Adopting your analogy.
yes,
So some people find their pot of gold.
yes,
Some people who don't have the protected characteristic find their pot of gold
yes,
quicker than those who do have the protected
Yes.
characteristic.
so I'm going to have to modify the pipe because you've got different pipes running at different speeds depending on priority under the policy as a whole. So certain people will have higher priority than other people. That's completely correct. You don't all have the same chance under the allocations policy. So that's why the pipe shouldn't be used as an analogy.
But I know we're at time, but she's talking about within the cohort of homeless people. I suppose the question is, why should a non-disabled homeless person get there quicker than a disabled homeless person?
Yes. So she first of all said, look, the complaint is that we've got a smaller pool of properties. But then she said, oh, well, actually, we don't need any adapted accommodation. So her client is in exactly the same position as anyone else within that category. There are exceptional circumstances, and her client applied for this to say, look, my medical needs are such that I need to be bumped up from this grouping into a higher priority. And there was a finding of fact under that exceptional panel that they didn't have those circumstances, and that was not appealed. So there is an ability under this policy to move from that category up. It's much more nuanced in relation to that decision, because the local authority is saying, in the main, you are not going to satisfy that criteria because you're mainly going to be in suitable accommodation under this category. And the exceptional category only applies, if you look at the policy, where your accommodation is, your long-term health and well-being is being affected by their current housing accommodation. So that's the gateway into that. It's not just, oh, I've got very pronounced medical needs. It's the accommodation that I'm in currently is affecting my health and well-being.
Right. Well, I think that might be a good moment. And we will resume. How long have you got, Mr. Paget?
I think I have 1 hour.
Good. We'll resume it.